A franchise company with over 200 locations just published a blog post to defend themselves from months of public criticism. And in doing so, they accidentally confirmed every single thing their critics said. Let me explain why that is the most self-defeating PR move I have seen in a long time. If you haven't been following this story, here's the short version. Bricks and Minifigs is a Lego resale franchise chain, more than 200 locations across the country. For the past several months, a YouTuber named Reckless Ben has been documenting what he calls systematic fraud against franchise owners. Missing inventory, assets seized without documentation, former franchisees saying their stores were taken over and stripped, with no third-party evaluation, no inventory list, nothing. Ben's documentary series has been gaining serious traction. Part 3 just crossed 5 million views, and the more views it gets, the more pressure lands on Bricks and Minifigs corporate. So they published a blog post, dated July the 10th, 2026, 2 days after Part 3 hit millions of views. The timing, as they say, is not a coincidence. On the surface, it reads like any other corporate damage control. We hear your concerns, we're making improvements, we stand behind our legal position. Boilerplate. Fine. But here is the problem. This blog post announces 7 specific operational improvements, and every single one of those improvements corresponds directly to a documented failure that critics have been calling out for months. Not similar failures, not adjacent issues, the exact failures. Which means that by announcing improvements, Bricks and Minifigs did something extraordinary. They wrote their own confession. Let's go through them one by one. Improvement number 1, field coaches. Bricks and Minifigs says they recently hired experienced field coaches to provide more consistent insight into store operations. The key phrase is increases store-level visibility. Think about what that means. Their main defense throughout this entire saga has been that they didn't know what was happening inside individual franchise locations, that the Salem situation happened without corporate knowledge, that they can't be responsible for what they didn't know. But if they'd had field coaches with store-level visibility, they might have known. And by announcing they're adding that oversight now, they are confirming it didn't meaningfully exist before. Improvement number 2, franchisee qualifications. Since 2023, they say, they've improved how they screen new franchise candidates. Background checks, higher financial requirements, stronger internal expectations. Since 23. Crystal Log Gorman, Brandon Best, Joshua Johnson. The franchise owners at the center of this controversy, all of them were qualified before 2023, under the old process. The one Bricks and Minifigs is now describing as inadequate. They also mentioned tripling the cost to become a franchisee. In 2023, it was $99,000 to $225,000. By 2025, it jumped to $570,000. Now it's up to $600,000. And they're framing this as a qualification improvement, as if having more money in your bank account makes you a more ethical business owner. I'm not sure what argument they think they're making there, because money and morality are famously not the same thing. Improvement number 3, inventory system. They announced they've invested significant resources into a new inventory management system and that they now require all franchises to use it. We now require. Present tense, meaning they did not require it before. Here's why that detail matters so much. Ben's entire Part 3 was built around trying to get an inventory list from Bricks and Minifigs. They refused. Crystal says she never received an inventory when her store was taken over. The Clackamas County franchise owner said the same. Assets were taken with no inventory provided, and no location of the assets was ever disclosed to him. And Bricks and Minifigs' own attorney told Brian's attorney in writing that they had no legal obligation to provide one. No legal obligation. In writing. Now they're announcing a mandatory standardized inventory system across every location. The only logical conclusion is that the inventory chaos at the center of Brian's case existed precisely because no such system was required. Improvement number 4, offboarding with third-party inventory evaluations. When stores change hands going forward, there will be a third-party evaluation of inventory and fixtures. Crystal never got one. The Clackamas County owner never got one. Bricks and Minifigs took over stores, said they'd handle everything, and moved on. And now they're announcing they'll do what critics said should have been standard practice all along. Improvement number 5 is genuinely remarkable. Board expansion. They're adding outside perspectives and a franchisee voice to their board of directors. This is a company with over 200 franchise locations collecting more than $13 million a year in franchising fees. And until this blog post, their board had no franchisee representation and limited outside oversight. That means every decision about inventory policies, store transitions, mandatory minimum payments, all of it happened inside a structure with no external checks. No independent voice asking why stores were changing hands without evaluations. No franchisee representative raising concerns about how assets were being seized. Nothing. They are only adding those voices now, after the consequences became public. And then there's improvement number 6. Leading with empathy and accountability first, clarifying facts second. Direct quote from the blog post, which is an indirect admission that they did the opposite. Ammon McEnee went on Fox News and made statements directly contradicted by documented evidence. They told Brian's attorney the matter was closed and they had no legal obligation to return anything. They banned Ben from even requesting the inventory list in writing, calling it harassment. They sued him. That is the opposite of leading with empathy, and they know it. Here is the central contradiction this blog post cannot escape. In the same document where they announce these 7 improvements, Bricks and Minifigs writes, and I'm quoting directly, "While much of the public discussion has been based on incomplete or inaccurate information, we also recognize simply correcting misinformation isn't enough. They are calling the criticism misinformation, but you cannot simultaneously call the criticism misinformation and announce that you're fixing everything the criticism identified. You don't get to do both. Either the criticism was wrong, in which case why are you fixing those exact things? Or the criticism identified real systematic failures, in which case why are you calling it misinformation? They cannot have it both ways. Reckless Ben was right. The inventory chaos was real. The offboarding failures were real. The board with no outside oversight was real. The pre-2023 qualification failures were real. Bricks and Minifigs confirmed every single one of them, in their own words, on their own website, in a post they published trying to defend themselves. Now, about this lawsuit. The blog post says Bricks and Minifigs remains open to a mediated amicable resolution. Here is what that actually looks like right now. They are seeking at least $1.3 million from Ben, with lawyers indicating damages could exceed $10 million per person. There are 16 defendants. Do the math. $10 million times 16 defendants. That's $160 million in potential damages. From a franchise chain suing a YouTuber for making YouTube videos about them. Ben has had to hire 5 separate attorneys to cover the different categories of charges, each one requiring a specialist. The case is in federal court. His attorneys have publicly stated he intends to file a counterclaim. His next criminal hearing is September 15th, with charges that include stalking, targeted residential picketing, disorderly conduct, and trespassing. That is not a company pursuing an amicable resolution. And here's the detail that makes this even richer: the preliminary injunction they're framing as a win for their brand. That same order explicitly protects Ben's right to keep posting on YouTube, TikTok, Instagram, and every other platform, to keep publishing court filings, to keep doing investigative journalism. The injunction they called a victory for Bricks and Minifigs is the thing that allowed Part 3 to go live. This blog post was supposed to repair the damage. Instead, it became a document of admission. Every improvement is an acknowledgement. Every operational change is a concession. And the lawsuit, rather than silencing the story, is keeping it in every news cycle indefinitely. Ben's documentary is at 5 million views and climbing. The counterclaim is coming. The hearing is September 15th. Bricks and Minifigs wanted to close the book on this story. They just wrote the next chapter.